uh, by Brian Christopher Jones, spoken at the center before. He's a great friend of ours, and we are very happy to welcome him back. But also some of the contributors to the book, as well as three other discussants who are very well-known experts in the subject matter of the book, all located or have been located in Asia, working in Asian jurisdictions, and very familiar with the kinds of controversies that the book touches on and contributes so such a nuanced and sophisticated way to our understanding of a very very interesting set of developments that are taking place in Asia. Uh, the global rise of China is obviously having certain implications for the way comparative constitutional law has traditionally functioned in the post-Cold War world, and it is increasingly clear that these concerns are becoming very much a concern of mainstream comparative constitutional law, whereas previously it was only sort of area specialists who used to deal with Hong Kong or Taiwan or Malaysia and Singapore, and certainly in South Asia that has been the case. But increasingly, because of these matters becoming issues of global concern, they are becoming much more mainstream. So we are very happy to see that this very interesting work happening, and we are happy to and delighted to actually host Brian, his contributors, and also the discussants at this ECCL event. This event will take place in the form of a round table, so unless there is some time at the beginning, there generally will not be Q&As. Um, and in the email, you have seen the order that we are going to go in. Essentially, I will quickly introduce all the presenters quickly. Then Brian will kick off 10 minutes introducing the book, and then we will have Amy and Chien-Chih, who are two contributors to the book, also saying a little bit more about the book and their chapters. And then we will have three discussants who are not contributors to the book, who will be discussing the book in the form of Maartje De Visser and Wen-Chen and Stephen Thomson, who will be slightly late to join, but will be joining us in due course. So Brian is a lecturer in law at the University of Sheffield. He serves currently as the co-convener of the public law section of the Society of Legal Scholars here in the UK, and is also a member of the SLS Executive Committee. His research focuses on public law, aspects of constitutional theory and comparative constitutional law, and the interaction between law and politics. Brian Christopher Jones is the editor of the book around which this event takes place. Then we have, next we have Amy Barrow, as a senior lecturer at Macquarie Law School and a member of the Centre for Agency, Values and Ethics in that university. She also leads the Activism, Rights and Justice research stream in the Faculty of Arts. She has a keen interest in interdisciplinary research, and to date her research has focused on two principal themes: the intersection between gender, international law, peace and security on the one hand, and the law and society in Hong Kong and other Asian contexts. The third contributor to the book that we have speaking today is Chien-Chih Lin, who is an associate research professor at the Academia Sinica in Taiwan. He has written widely on constitutionalism in Taiwan and East Asia. He's an editor at the International Journal of Constitutional Law and a national correspondent for the Journal of East Asia and International Law. So welcome to all three of you. And then we have three very established discussants to discuss the book. Going first would be Maartje De Visser, who is an associate professor at Singapore Management University. Maartje specializes in engagement with constitutional rules and values outside the courtroom, on constitutional courts, transnational judicial dialogues, and comparative pedagogy and methodology. Her current projects include frameworks for extrajudicial constitutional interpretation, participatory constitution making in small states, and cultivating constitutional literacy and identity. Going second or third, depending on when Stephen Thomson is able to join us, would be Stephen Thomson, who has recently returned after a substantial spell teaching at the University of Hong Kong. Specializes in administrative law, constitutional law, and human rights. Stephen is, of course, also an alumnus of Edinburgh University. He did his PhD here. And his appointments include as legal advisor to the Ombudsman of Hong Kong, as a member of the Constitutional Affairs and Human Rights Committee of the Law Society of Hong Kong, and an examiner on the Law Society of Hong Kong's Lawyers Qualification Examination. And finally, we have Wen-Chen Chang, professor at the National Taiwan University. Wen-Chen focuses the teaching and research on comparative constitutions, international human rights, international environmental law, administrative law, and law and society. Since February 2019, she's jointly appointed as Dean and Professor at the National Chia Tung University School of Law. Wen-Chen has a very distinguished research and publishing record, which I'm not going to recount here, but we are all very pleased to have you. Thank you so much for joining. And without further ado, I think I will just hand over now to Brian to kick off. Thank you.
All right, thanks so much. And thanks to Asanga for the invitation. And thanks also to the speakers and the discussants for joining us as well. Such a stellar lineup today. I'm really pleased to be back at the Edinburgh Centre for Constitutional Law, and of course to be part of such an excellent event. So rather than delving into my chapter, which is on court criticism and the rule of law, I'm going to provide kind of some general comments and reflections on the book, which is of course strategically placed behind me there. Let me start by saying that I think publication feels a little bit kind of bittersweet. And I'm really proud about the book that we put out. So it is kind of a follow-up to a previous collection, Law and Politics of the Taiwan Sunflower and Hong Kong Umbrella Movements. And I think we, do justice to some of those developments, especially in part one, and talk about some of those implications. But we go beyond those, right? We look at rule of law and democracy and kind of how it plays out in certain jurisdictions. And so I'm really proud of that. I think we have some really, interesting and insightful chapters in the book. And we have kind of a wide variety of authors as well. So we have kind of early career authors, we have well-established authors, and kind of all of those in between as well. And we also have authors from, a variety of places. So the UK, Taiwan, Hong Kong, Macau, Singapore, Australia. So it's really truly was a collaborative project. And it was great to work with these authors. And I think the process was so much easier because of them. And so I was very lucky as an editor to work with such a talented group. I think we also have some brave chapters in this collection. And I think we have some chapters that say kind of some new and fresh things. And maybe I even think some things that people are a bit hesitant to say. So I think that is something that I'm proud of as well. The book also has a personal element also. So I'm married to a Taiwanese citizen, and we have 2 children that are Taiwanese, and not to mention many friends and family in Taiwan and Hong Kong. So a lot of these issues that we're talking about, hit home, right? Because they impact people that I know and love in these jurisdictions. And also, finally, something that I'm proud of is I think that these issues, as much as they matter for kind of the jurisdictions that we're talking about and the jurisdictions that are kind of in China's shadow, I think it's readily apparent that they also stretch beyond that, right? There are many, I think, chapters and issues and kind of insights into kind of the way that rule of law and democracy operate that flow beyond just these chapters or just these jurisdictions. And so I think that is something also that I'm proud of in terms of this book. But let me also say that it's bittersweet because I think the optimism that I had when I started the project has kind of dwindled a little bit. With Taiwan, we're used to hearing about, its dynamism. I think it's a really vibrant democracy, a really vibrant place to be. And we used to hear about, all these great things from, same-sex marriage developments to other political developments. And now we hear kind of less about, those developments and more about, Taiwan's kind of fractious relationship with China and, China's desire to swallow or unify Taiwan. And so I think that has kind of increased over the last couple of years or so. Also, in Hong Kong, I think there was a really interesting period there from kind of 2014 to 2019, where we saw this kind of resurgence in interest in democracy in Hong Kong, right? And we saw, people looking to things like the Basic Law to see, what it said about democracy and, how democracy was going to be delivered. And there was a really big discussion on, what genuine democracy is, and how that's going to play out. And that's kind of fallen by the wayside a little bit. It was extremely difficult, I think, to finish up the book when we did, right? So many developments going on, especially on the Hong Kong side, right? Various people being arrested, various newspapers closing down, new laws being passed, like the national security law. So it was really difficult to know, when do we stop, right? When do we, there can't be a new chapter for, all of these developments. And that was challenging, knowing when to stop and, being happy with what we covered. And so that is something that was difficult. And also, let's not forget that the things that we're discussing here, I think are quite serious. We have an author in the book, Benny Tai, that's lost his job. And last time I checked is currently imprisoned. And for what, right? For advocating democracy, for advocating peaceful protest, right? Not for this event, but for other events. I've asked authors of the book to talk about their chapters, and they've been hesitant to do so. And I think that's something that's really telling about kind of the state of, the national security law in Hong Kong, and maybe some of the chilling aspects of speech in relation to that law. So the things that we're writing about, things that we're discussing, sometimes they can seem, really abstract, but there are people that are living these things, right? And living these developments, right? And have to deal with this on a daily basis. And I think, some of these things, really play out in the book. And there's some things that are very important, right? That we need to recognize. So I'd like to talk about two things before we get on to the other speakers. And one of those is that, Taiwan, at least to me, is a reminder that, not everything has to be about economics, right? So sometimes I think we lose sight of this, especially when, constitutional issues come into play. Economic considerations are definitely relevant, of course they're relevant, but also Taiwan to me shows that governmental arrangements, right? And how things are structured and the operation of democracy within that state can be just as important, if not more so, than economic benefits, and of course we saw this play out in 2014, right, with the scuppered trade pact with China that absolutely would have benefited Taiwan economically, right? So it would have benefited Taiwan's GDP, but sometimes countries have to make difficult decisions about things that could hurt their GDP, right? But may in the long run be more valuable to their state and to the operation of things like democracy, right? And I think that's a really valuable lesson, not just for Asia, right? Or countries that operate in China's shadow, but even beyond that, right? That there's things that go beyond GDP that states need to worry about. And I think also that differentiates Taiwan from some of its neighbors as well, right? I think we have Taiwan's neighbors, are really good at the economic bit, right? They're really good at, making sure citizens are comfortable, making sure citizens have what they want, and making things kind of easy for citizens. But maybe they're not so good at the state structure aspect bit. And maybe they're not so good at the governmental arrangement bit, or the operation of democracy bit, or the providing of kind of rights and freedoms bit, right? So I think that is something that, you know, differentiates Taiwan. And finally, I'd just like to talk about the importance of free speech, especially in light of the national security law. And I think there's three aspects there that I'd like to discuss. The first one is that I think free speech allows for the unencumbered dialogue to take place amongst citizens and also between citizens and the state, right? And for citizens to be able to freely engage with their fellow citizens, right? And search for that truth on various issues and problems that society faces, that is inherently valuable, right? And subsequently, if democracy is about paying attention to citizens, then knowing what is important and what is valuable to citizens, what is relevant to citizens, also helps government, right? And helps democracies function, right? And it helps government respond to citizens' requests as well. Secondly, in relation to free speech, I think it allows people to know what their true history is, right? They may be beyond what the state is telling them their history is, right? Beyond what's in kind of official documents, such as, you know, constitutions or constitutional preambles, right? The state may have one version of history, but free speech allows for societies to have more than that official version, right? And I think that's inherently valuable. And finally, I think free speech allows people to recognize and reflect on constitutional mistakes, right? Every regime has constitutional mistakes, right? But at least free speech allows for the recognition and acknowledgement of those mistakes, and therefore the opportunity to put them right, or maybe even, you know, not make them again, right? So I think there's some important aspects to speech that I think we see the national security law potentially impending on. So thank you so much. I'm going to end it there. I look forward to what the other presenters say in relation to their chapters, and of course, look forward to what the discussants say as well. Thanks a lot.
Thanks, Brian. Amy, the floor is yours.
Thank you so much. Thank you, Brian, as well, for inviting me to be part of this book project. And it feels like that initial conversation was quite a long time ago. And I'd also like to thank the Edinburgh Centre for Constitutional Law, but also for the other panelists here today. And I'm really looking forward to the discussion. I think when I had those initial conversations with Brian about the book, I was very excited to be part of it. I'd lived through a really significant period in Hong Kong's history through the umbrella movement. My daughter was born in Hong Kong. My partner's Taiwanese as well, so there's a connection there. And I met Brian a long time ago in Taiwan at a conference. So that's where we connected previously. But I think what I didn't realize when I started looking at this chapter was just how intensive the changes would be within the region and within Hong Kong. You know, when I had my primary discussion, this all occurred prior to the anti-extradition law amendment bill movement, prior to the start of the COVID-19 pandemic, prior to the imposition of the national security law. And they're key variables which I think are shaping conversations now going forwards. Like what does the rule of law and democracy mean in the shadow of China? And it's impossible to look at that without considering these developments. So when it came to writing the concluding chapter, my aim was really to try to contextualize the author's contributions in the light of these variables that were unforeseen at the time of writing. And also then to think about the consequences going forwards of these variables. So I'll speak a little to some of those variables. But I guess one of the central themes that I wanted to pull out in my chapter was about the relationship between rights, the rule of law, and resistance. And I think, you know, what Brian said about the Taiwanese context is very important. Like when we look at Hong Kong and Taiwan, they increasingly diverge in terms of their political trajectory. And I think certainly what Brian said, recently there's been a lot of consideration, you know, about this fractious relationship between China and Taiwan, and there's been a lot more rhetoric around peace and security in relation to Taiwan and China. And that detracts in many ways from the fact that Taiwan is this pluralistic, vibrant democracy that's made significant progress on human rights, on LGBT rights, and also try to really play a role in the international community, even though it's denied that membership to be part of the international community. So when we compare Hong Kong's trajectory, we see that it's sliding towards increasingly hard authoritarian governance. And I guess both were post-colonial societies, both did have economic success. And I guess the one distinguishing factor in many regards is this one country, two systems constitutional configuration. And although that's contained within the basic law and it's a principle, and that means that there should be a period of 50 years up to 2047, where the way of life remains unchanged, this capitalist way of life and the common law system shouldn't be altered. In many respects, with this increasing intervention in Hong Kong's political and legal affairs, that we can see that, you know, this experiment of one country, two systems is very difficult to sustain. Hong Kong is a society in transition. It's a regime in transition. It's a hybrid regime. It's often described like that. And it's been described, you know, Benny Tai has referred to it as being semi-authoritarian. There are some constituent elements of democracy. But I think it's important to think about what Hong Kong is transitioning from and what it's transitioning to. And it's beyond the 2047 period that there's no kind of real clarity. But I think the events that have taken place really do raise concerns about what this means for the rule of law and democracy within Hong Kong, but also beyond Hong Kong, because we do see increasing rhetoric about Taiwan's situation. I guess one of the things in terms of thinking about Hong Kong as a post-colonial society, there was a window of time. There was a period pre-handover where there was an attempt to strengthen human rights and civil liberties. But I think this is very fragile, really. You know, you haven't had a significant period of time to really entrench those rights within the Hong Kong context. But I think there's a generational aspect to this, you know, certainly for the younger people who've grown up with these rights. You know, they don't want to lose sight of those rights and they don't want to lose them. But it's quite fragile when you see that there is this increasing intervention from the central people's government in Hong Kong's legal and political affairs. And it makes you question about the sustainability of these rights-based protections that are contained within the legal framework. I guess when I was looking at some of the chapters, for instance, Fu Hualing and Michael Jackson's chapter, they look at the increase in public meetings and the number of assemblies that have taken place within Hong Kong. You know, it is a city of protest. And I think in many respects, that resistance wouldn't have been possible if it were not for this rights-based legal framework and some of the rights that were interjected into the basic law. In many respects, I guess the Tiananmen Square massacre was really a critical political juncture for the British colonial government to try to strengthen public confidence in the impending handover. So the creation of rights-based protections became critical, really, to building the confidence of the population in the handover period. But I think it's really disturbing in many respects to see the developments as they have unfolded in Hong Kong. And Zhu, in his chapter on China, has looked at how law is used as a tool to stifle anyone who challenges the existing constitutional configuration. And we start to see that taking place in Hong Kong. And for me, I was there at that period in time when there was the oath-taking scandal, and it was very disturbing that due process is not being followed, and you have the intervention from the Chinese government, and you know, 2 pro-independence lawmakers are disqualified. So you see that law is actually being used as a tool to stifle any kind of dissent, and I think that's deeply disturbing for me. So in terms of trying to think about these variables and what it means going forward, Obviously, within Hong Kong, it was a critical period in 2019 with the anti-extradition law amendment bill protests that took place. There was significant political unrest, civil unrest, and escalating violence. There was a lot of discussion around police brutality, allegations of police brutality. But essentially what came out from that period was the way in which protesters were being framed as rioters, even though there was a lot of peaceful protests that actually took place during that period. And the way in which this movement, which originally was around this law that was going to allow for an extradition agreement to be developed between Hong Kong and China, and Hong Kong and Taiwan. And it became much more holistic. It was also deeply connected with democracy. At the same time, it also resulted in the framing of that movement being perceived as a national security threat with the Chinese government. So the second variable also that I wanted to think about is, all this was taking place. It seemed like this prolonged period of civil and political unrest within Hong Kong, but then it was forced to stop in many respects because of the pandemic. Now, I don't think anybody could have imagined, like when they were writing their chapter, that this pandemic would take place. And I think when we start to see some of those images that emerged from around the world throughout the pandemic, starting off with what occurred within Wuhan, and seeing about the silencing of whistleblowers, that we kind of imagined that would take place within an authoritarian regime. So it's maybe not surprising to see some of those images. But then when you start to look at your own state and you see some of the practices that have taken place within our own countries, I'm British originally, but I'm here in Australia, and I've literally just emerged from a 100-day lockdown in Sydney. There's been an extensive track and trace process system, which could be considered an invasion of privacy. There's lots of different measures, emergency measures and public health measures that have been implemented that are also potentially problematic for civil liberties. And I think, I'm not sure if Stephen Thomson's here yet, but he wrote a really very interesting article about whether we're experiencing an impending authoritarian pandemic, along with a colleague from Hong Kong University, Eric Ip. And that is very interesting to think about what has taken place throughout the COVID-19 pandemic, and the fact that even, this idea about authoritarian governance, we look at China and we see that as an authoritarian regime, but we can't lose sight of the fact that authoritarian governance practices are also taking place in Western liberal democracies. So this deterioration really of the rule of law and democracy, is expanding across different jurisdictions. So it's a stark reminder that authoritarian governance can exist in enclaves within Western liberal democratic context. And I guess the third variable, and Brian talked about this with the national security law, when it happened, in terms of writing this chapter, is like, oh my goodness, the national security law has just been passed. I can't avoid talking about this. I don't want to self-censor, but how am I going to tackle this issue within my chapter? Because, it really is quite pointed, like having to think about, what are the implications of this? What can I say? What can't I say about this? And there's a colleague who works at SOAS, Yan Ho Lai, and he's been working on, he's a Hong Kong scholar, but he's kind of talked about this fact that it's now from rule of law to rule by fear. And we can see that this is taking place within the Hong Kong context. And I think about all the things that have been taking place. And Brian mentioned about, for instance, Apple Daily, a major tabloid, being shut down. We've seen the disbandment of groups like the Progressive Lawyers Group in Hong Kong, who are a group that were pro-democracy, wanted to defend the rule of law. They made various submissions to international parliamentary bodies in US Congress, the UK parliamentary committees, also in Australia. They've just disbanded in July 2021. Only this week, Amnesty International have just decided to close their offices in Hong Kong. It's no longer tenable. And you even have a situation where this law, which is incredibly malleable and broad-reaching, is not only going to affect China's relationship with Hong Kong and Taiwan, but it also affects other jurisdictions more broadly, like in the Asia Pacific, but beyond that. And so one example is only just this week, Louise Ho, who's Hong Kong's customs chief, has actually talked
Amy,
about
really sorry to sort of interrupt you. It's fantastic stuff, but I would need you to wrap up as soon as possible. Thanks.
Yeah, I just wanted to make this point that the Hong Kong customs chief, Louise Ho, has described the smuggling of rock lobsters from Australia to Hong Kong as a potential national security threat. So it's this idea that almost like anything and everything could potentially be a national security threat. And I think that's deeply problematic going forward. So it raises some significant questions for what this does mean beyond China, beyond these jurisdictions that are directly in the shadow of China. Thanks.
Thanks very much, Amy. Thanks. So much there to think about. Chien-Chih, you have 10 minutes, please.
Yeah, sure. I guess, thank you. I would like to thank Brian first for the invitation. It was my great honor to participate in this project, which is very meaningful to me. And actually, this chapter is, I would say, one important stage of my project that focuses on constitution making in Taiwan. And I guess that's why, how do I say? I would say, like, you know, as a Taiwanese or as a Taiwanese common law scholar, I guess what bothers me most is that we, I mean, Taiwanese, are not really governed by a constitution that is written for Taiwanese. So I guess in my presentation, I'll provide some background knowledge first. And the constitution or the supreme law in Taiwan is officially known as the Constitution of the Republic of China, not the Constitution of Taiwan, which is why, and of course, you know, Taiwan is officially known as Republic of China. And the constitution was actually written in China. I mean, not written in Taipei or, you know, other cities in Taiwan. It was written in China in 1947. And as you know, our discussant, Professor Chang, has famously written a paper that, and at that time, Taiwan was a province of China. That's for sure. And I think there were like 18 Taiwanese representatives that participate the constitution making project in China for enacting the current constitution of the Republic of China. But their appearance in China was actually, you can say, token, in the sense that they do not really, you know, influence or impact the content of the constitution in any way. So that's basically the supreme law in Taiwan so far. And in my chapter, I actually point out several problems, procedural problems and substantive problems of our constitution, which is why I entitled my chapter "Undemocratic Constitutional Law." And the first is that, procedurally speaking, the constitutional law was not written for the Chinese people, which is why I think it's procedurally undemocratic. And even though the constitution, after it was relocated in Taiwan, the Taiwanese people has amended the constitution 7 times. But this amendment, in my opinion, do not really fully justify or enhance the democratic legitimacy of the constitution. And one of the reasons is that, you know, Chinese people do not really care about constitutional amendment that much. For example, the latest constitutional amendment was enacted in 2005. And at that time, only, I can less than a quarter of Taiwanese people really voted. I mean, less than a quarter, I think it's about 23% of Taiwanese people voted. And this, in fact, so therefore, the latest constitutional amendment, the legitimacy of our constitutional amendment was actually questioned by at least 3 justices of our constitutional court. And the reason is because, the turnout is so low that, we don't really know, how democratic legitimate these constitutional amendments are or, have been. So you can say, procedurally speaking, both the Constitution and the constitutional amendment are questionable. And in terms of the substantive problems, I think that we have more serious problems in terms of the contents. I'm sorry for those who are not really familiar with the content of the Taiwanese Constitution, but anyway, substantively speaking, since the Constitution was made in 1947, and it was made for at that time, there was no People's Republic of China. There's only one China, which is known as the Republic of China. So the Constitution was made, you can say, was written for a geographically immense country that include mainland China, Taiwan. Actually, it did not include Hong Kong. That's interesting to note, because at that time Hong Kong was, still. But anyway, so it was written for, you can say, Chinese people, mainly for those people who live in mainland China. So you can imagine that, for example, the easiest question is, for example, the agency cost at that time was particularly serious because China was such a big country. So therefore, there are some institutional designs that were, you can say, enshrined or entrenched in the Constitution specifically to address this agency cost. And the control yuan, for example, one of the coordinate branch of our legislature, is one of the problems. It might be fine, in the Chinese context, but when the Constitution was implemented in Taiwan, a small, tiny island, the Constitution was problematic in terms of implementation. And also, some of its provisions was actually, essentially repealed in the sense that they are not binding at all, even though they are not amended anyway. But I guess for the interest of time, I will focus on one major issue, and that's the One China policy. I would say it is embarrassing to admit that our Constitution, the Constitution of Republic of China, or the Constitution of Taiwan anyway, in a sense or to a great extent enshrines, if not entrenched, the One China policy that most Taiwanese people oppose. I guess I'm confident to say that most Taiwan people oppose the One China policy currently, but it is embarrassing to admit that it is enshrined in our, or I would say, in the preamble of our constitutional amendments. The preamble of our constitutional amendments, let me read it for you, said that to meet the requisite of the nation prior to nation unification, the following articles of our constitution are added or amended. So, I mean, there are many possible interpretations in terms of this preamble, which said, we aim to, national unification. There are many possible interpretations. Some Chinese scholars think it's simply a guideline in the sense that it is not binding. But others think, oh, it is a constitutional obligation that the government should obligate, at least its policy should anyway, national unification, if not reunification, is the ultimate goal because it's written in the Constitution, or at least written in the preamble of the Constitution. And actually, let me quote Wang Yi. Wang Yi is the current Ministry of the Foreign Affairs of People's Republic of China. He once actually said that, hey, look, Taiwanese, even your constitution enshrines One China policy. How could you deny this? I mean, deny this, by this, I mean that Taiwan and China belong to one China. So, I mean, as a Taiwanese, I have to say that it is embarrassing to admit that constitutionally speaking, or at least textually speaking, he had his point to some extent. So I guess that's the major issue. And people may ask, then why don't you rewrite a new constitution, or why don't you erase, the preamble that you'd find, undemocratic? And I guess that's the point I want to make. And the point is that because of the constitution making is so symbolic that it is, you can say, equivalent to declaring independence, which is, of course, a political tattoo to the Beijing government. It may be, or it could be, an excuse for, armed conflict between Taiwan and China if Taiwan, quote unquote, dares to enact a new constitution. Even constitutional amendment would, spawn some, fierce protest or something, from China. So you can say, in a sense, we as the Taiwanese cannot really rewrite a new constitution to address the constitutional problems that I have sketched so far because of China's opposition, or if not intimidation. And that's, I think, the core problems of all Taiwanese, of all constitutional scholars in Taiwan, if not all Taiwanese people that currently face. That there are some important issues, for example, the one China policy that we enshrined in our preamble. But however, we cannot, address that. And I guess I will stop my presentation here because I'm looking forward more to the discussion here. And as I said, this is one important stage of my project that focuses on constitution making in Taiwan. So I look forward to the feedbacks. Thank you.
Thanks very much, and thanks so much also for keeping to time. Although we have now a little extra time, Stephen Thomson has just got in touch to say that unfortunately he's not going to make it this morning. His illness has worsened, so we wish him well. But for now we have a little bit more time, so maybe we will have Maartje and Wen-Chen, and possibly a few minutes for a question or two, hopefully. So thanks to the contributors. Now it's time for the discussants. So Maartje.
Thank you so much for
15 minutes.
Yes, I will try and stick to time and hopefully come in slightly under so that we might have a bit more time for discussion, because I hope that might be interesting.
Great, yes.
Thank you so much for inviting me. It's a real pleasure to be in Edinburgh. I am originally from the Netherlands, so you would think that I would have been able to make it to Scotland by now, but I haven't yet. So at least this is a virtual appearance, and I hope at one point we might have the possibility of a face-to-face convention. Now, let me start by congratulating Brian on the book and Amy and Chien-Chih for contributing. I think it's a wonderful contribution to the literature. And I think it's a good contribution to the literature for two reasons that I hope will resonate with what Brian has mentioned. The first is that it fits beautifully with a growing corpus that needs to really expand, that envisages the Global South as an object of research in its own right. So what we are really beginning to see is that, and I made that quip earlier before we started the event, Asia is being rediscovered, and it's rediscovered academically, not just as a place where we will find transplantation of whatever happens in the West or the North, depending on one's geographic predisposition, but as a place where there is a lot of exciting activity going on from a constitutional perspective that does not necessarily follow the linear trajectory that would lead us to liberal constitutionalism in the very end as the ultimate endpoint of any good constitutional development. So I think that's a very, very important contribution that we see here. And the second is this, and it relates to the question about the freedom of speech. So Brian mentioned freedom of speech for individuals to engage with one another and to engage with, if you want, the polity and the state. But it's also increasingly the freedom of speech for us as academics. And here it's almost concerning to see that this is becoming a topic of acute academic interest in its own right. So I hope that this volume will stand as a testament to the importance for all of us to take courage and to speak our mind, because if we do not speak up for the values that we believe in, or if we are not the ones commenting in an objective and, you know, in a way dispassionate way on legal developments, then who will? So I would say this is not necessarily a plea for academic activism, but at least it's a plea for almost academic honesty, as much as it is difficult at times when we might feel that urge to self-censor. Now, when we spoke, we being Brian and I, when we spoke about this volume and he invited me to act as a discussant, one of the points that he mentioned is that there is one chapter on Singapore, and it would have in a way been wonderful if the country had been featured more prominently. So I thought, well, I'll take my cue from that and then perhaps share a bit more about Singapore, because we have heard about Hong Kong and we have heard about Taiwan. And what I'd like to do, and perhaps that's the eternal optimist in me speaking, to sketch out some developments in Singapore that might give us some cause for optimism, or a sense that there could be other interesting developments happening in Southeast Asia. Now, what I will also do is this: the chapter about Singapore in the book talks about the role of the judiciary in providing judicial review when it comes to the recognition and protection of the right to be represented, so the right to a representative democracy. Now, what I'd like to do instead is focus a little bit about on Singapore in a democratic fashion outside the courts. And what I think we see here is that academically, Singapore has variously been described as a dominant party state on account of the People's Action Party, the PAP, having been at the helm since independence, despite some inroads being made by the opposition, which is growing increasingly stronger. It's also been described, I think, most famously by Mark Tushnet as the classic example of an authoritarian country where there are curbs on personal freedoms and statutory mechanisms that can, and he would arguably say, have been used to preserve the political status quo. But it has also been described, including by Singapore academics, as a state that practices a form of illiberal constitutionalism. So if you want the counterpart to the liberal version that I mentioned earlier. And the version that has been identified in relation to Singapore is that of communitarian constitutionalism, or the country having a communitarian rule of law. Now, this in fact is a characterization that is also embraced locally. So political elites and judges have similarly referred to Singapore's brand of constitutionalism as being communitarian in nature. So I want to say a little bit about that and how that actually manifests itself outside the courts. And then I'd like to wrap up by offering some reflections on what that might mean for the role of scholarship going forward. Now, under a communitarian type of democracy or rule of law, there is a preeminence of collectivist values, a discourse that is centered on responsibilities and on a public good rather than on rights. And there often is an emphasis on strong states to keep the nation on course in realizing this public good. Now, in the case of Singapore, that public good is very clearly multiculturalism. And that's not surprising because the state is characterized by rampant pluralism. In ethnic terms, there are ethnically Chinese, Malay, Indian, and then what is known as others living there, notably referring to Eurasians. And the country is also religiously pluralist. And at the same time, another communitarian value is that of meritocracy. So there's an emphasis on a technocratic style of governance, on expertise, and on a sense of benevolent leadership that focuses very much on a top-down steering of governments knowing what is best for the polity. Now, one interesting way in which this manifests itself outside of what the courts are doing is that Singapore has increasingly adopted twists to what is the classic Westminster system of governance. So what we here see is that communitarian ideals have, in a way, changed somewhat the design of or the opportunities for representative government. And some have said that has also led to some differentiation in the electoral rights that citizens would hold. Now, the least, if you want, controversial of these is the existence of a presidential council on minority rights that simply vets all bills to ensure that these do not compromise the sensibilities and sensitivities of religious minorities or racial minorities. But what is perhaps more interesting to notice is that when we look at the electoral regime, Singapore has a first past the post system, but it doesn't just have single member constituencies. It has group representative constituencies, which means that for all of these constituencies, there needs to be at least one candidate to ensure ethnic pluralism in parliament. So here we already see a tension that can be at play between communitarian ideals. We also have nominated members of parliament that are meant to enhance the plurality of voices that is represented. So individuals that can be nominated by citizens and that bring to the table different types of expertise that is not necessarily drawn from their ability to come up with good political designs for the country. Now, the latest twist is the introduction of so-called reserved elections for the presidency. So Singapore has an elected head of state, a president. And in 2016, there was a discussion that the fear is that because of ethnic majoritarianism, the candidate for the presidency would always be someone who identifies with the Chinese community. And it was said that that might be problematic for symbolic reasons, as well as to give rise to certain ethnic fault lines that might become explosive in a way. So the country has identified reserved elections, which means as much that if a particular ethnic community has not held the post of the elected president for 5 consecutive or during the 5 preceding terms, then the next election is only open to candidates of that particular minority. So here we clearly see that multiculturalism and communitarian ideals in a way circumscribe the kind of representative democracy that is at play, because members that belong to a different ethnic community are unable to stand for office in that particular election. Now, there is another important point, which is that if we look to states that embrace communitarian ideals, we often need to look beyond the large C constitution. That text may give us some guidance, but arguably not enough. So we need to look to statutes, related policy documents to get a closer sense of the communitarian values that animate the polity that subscribe to this philosophy. Now, if I link this back to questions of democracy and the rule of law, when we talk about democracy and the rule of law, we often talk about rights in the exercise of, for instance, free speech rights, such as association or the ability to go to speaker's corner and say whatever we want. And what I think here is an interesting development in Singapore is that there are growing opportunities for public participation in a direct manner. So we see a greater space not for representative democracy, but for direct democracy. Possibilities to dialogue with the government. So one option or one way in which we see this is that there seems to be a greater use of parliamentary select committees. And that includes the use of these committees for acts that could be seen as potentially concerning from a democracy perspective, such as the Protection from Online Falsehoods and Manipulation Act, otherwise known as Singapore's fake news law. There were extensive parliamentary discussions about this, with involved the taking of expert evidence and massive public debate in newspapers and the like. When we talk about the reserved election, which was a massive change to the government regime, this was only the second time in the country's history since independence that a constitutional commission was set up. It was widely broadcast. Every citizen, every, if you want, permanent resident like myself, had the possibility to take cognizance of the changes that were being debated and could send in written submissions to the commission with some individuals being invited to give oral evidence later on. What is more, and that brings me back to those communitarian ideals of multiculturalism and relatedly racial and religious harmony, is that there are increasingly closed-door sessions with youths, so students and the like, about race and religion, where older generations would have said, these are the OB markers, the out-of-bound markers. We know that they're there, but we do not talk about them. That is the best way to preserve social harmony. That is changing. Younger citizens are talking about this. They're asking, what's your race? What's your religion? And the government realizes that it should engage with this if it wants to manage the narrative. So the government is beginning to do this. So we can see this in policies like our Singapore conversation, where citizens are not seen as just passive recipients of a top-down indication of policy, but they're asked what future they envisage for the country. So what they said, and here I quote, they said, we want to build a Singapore for Singaporeans, where we retain a strong sense of national identity. And the question, what that national identity should be, is increasingly fleshed out through, for instance, SG Future series or a Singapore Together movement. Now, as interesting as it is to observe this, the question then is, why do we see a change in direction? And I think here we see that there are competing demographics and concerns at play. So the older generation has lived through independence and has lived through the process of becoming a citizen and, in a way, listening to benevolent political leadership of what it means to be a good Singapore citizen. Younger generations were born as citizens. They were born into political stability and economic prosperity. So they have different expectations and they're no longer shy to make their voices heard, also because of the power of social media. Now then, a second point that I think is important to remember is that when we talk about dominant party states, a dominant party is not a monolith. If we look to the PAP, it's clear that there are certain factions. And presently, the country is wondering who will take the helm from the current prime minister, who is the son of the founding prime minister. And that is still very much an open contest with different factions, some that are more progressive and socialist leaning and others that are a bit more conservative. And I think we shouldn't lose sight of that just because a country has a dominant party. I know I'm running out of time, so let me just quickly sum up by highlighting 2 points as possible reflections when we study communitarian constitutionalism or the rule of law going forward. And the first is this. In the chapter, the authors close by saying that we might need a clearer distinction between communitarian and authoritarian constitutionalism. And I agree. And I think one very important question that we need to ask ourselves is, whose communitarian ideals matter? How are these framed and realized? What here is the role of society and whose name these ideals are being pursued? Do we see these ideals being established in a top-down fashion? Or do we have room for bottom-up voices? And here I noticed that Brian earlier referenced the role of history. Again, Singapore is coming to terms with its own heritage. And for instance, and this is a quick example I'll give you, there's talk about creating a founders monument to mark the turn to independence, with the population given the chance to speak out as to what design they would like and what they would like to see. So in a way, shaping their own historical narrative. Second, if we accept illiberal constitutionalism and communitarianism, we need to understand that these countries will have very different views of the nature of threats to democracy. Certain brands of nationalism or populism will be seen as far more dangerous and as warranting a response by the state because they directly threaten communitarian ideals. So one potential interesting way to explore this is to say, in the West, we talk about militant democracy And we say that is a good thing because it allows democracy to prevent or to protect itself from being jeopardized or being overthrown. How do we analyze statutes that might easily be seen as repressive? Are we here dealing with perhaps an Asian version of militant democracy, and what should we make of it? I'll stop right there. Thank you so much.
Fantastic. Thank you so much, Maartje. That was brilliant, both for your engagement with the book and highlighting some of the main themes, but also for that incredible primer on Singapore. I think these matters are coming to a head, and we're going to have some exciting years in comparative constitutional law discussing these things. Peter and Stephen probably would notice that if you replaced Singapore and East Asia with Sri Lanka and South Asia, I would have probably given exactly the same presentation on Asian constitutionalism. But there we go. Thanks very much for that. So for the last word, Wen-Chen, the floor is yours.
Thank you. I also want to start out by thanking for having me in this wonderful event. And it's been such a long time not to be connected with colleagues out there, particularly Brian. And then by way of saying to Brian also a big congratulations for this wonderful book, and also Amy and Chien-Chih for contributing to this book. Like Maartje, I also think this book has significantly added to the existing scholarship. By really answering or trying to answer a very difficult dilemma facing our own world that is going on now, democracy versus rule of law. So I was on the first book Brian put together immediately after Sunflower Movement and Hong Kong Umbrella Movement. At the time of finishing that book, I think scholars in Taiwan and in Hong Kong were pretty optimistic about what would be like in the future. Right? So on the side of Hong Kong, scholars would be hoping that the rule of law ever since developed in Hong Kong will gradually help to develop a more democratic Hong Kong with still a very strong rule of law. And then scholars in Taiwan will be looking forward to a more democratic, with the pretty much democratic foundations to the further strengthening of rule of law, constitutionalism in Taiwan. But like Brian has said in the very beginning, right? Just within 4 or 5 years, things have changed rapidly. Right? So on the side of Hong Kong, we were all disappointed in the way that the firm foundation of rule of law in Hong Kong has not delivered to generate a more democratic, robust system. It has been quickly eaten by the growing authoritarian power, first from mainland, then from Hong Kong ruling elite. So in that side of story, it seems that rule of law cannot really breed democracy. Rule of law cannot save democracy. Having rule of law only, it would be still very easy to lose democracy and altogether perhaps even rule of law. So that's pretty much the picture we have seen from the Hong Kong side. And what's the other side of Taiwan? So we see in Taiwan, the rule of law compared to Hong Kong has not been as strong, I would have to say, right? So we always in Taiwan have a lot of broad delegations to the executive authorities. And our courts at times sometimes are unbound and too easily perhaps to give out the rights and not to sustain the limits that should have been afforded to the legislature, to the executive. So, but our democracy has been always very strong. So if there's something wrong, then they are corrected by democratic forces rather than by legal forces. And then 4 or 5 years after now, then we see democracy continue to be pretty vital and strong in Taiwan, where the rule of law system is not as perfect, but is still there. So if we see the stories in Hong Kong and in Taiwan, we seem to be getting the sort of a temporary a standpoint to say, well, rule of law does not breed democracy, and rule of law does not even save democracy. But it seems somehow democracy can maintain democracy, and democracy can save somehow rule of law to the extent. If I paint the story as such, then we can look to the other side of the planet, Eastern Europe. There, Poland, Hungary, right? So we see they have a mixed picture of rule of law and democracy, right? Not necessarily like the bipolar picture of Hong Kong and Taiwan. So things are more mixed. And there, they are discussing whether democracy can save democracy, whether democracy would become too populous. Then you lose out democracy altogether, and then you lose out rule of law. So I want to start it to have this picture and to have this really dilemma between democracy and rule of law, two values so essential to constitutionalism that I think all constitutional scholars cannot afford to lose either. So, but then how? How can we work the two together in the scholarship of constitutionalism that we are engaged with, right? And not just scholarly, but also how can we work together these two values that we cannot afford to lose either in the jurisdictions that we are living, like in Taiwan, in Hong Kong, in China, or everywhere else. So I think that's a real challenge to us. And I, in this very sense, I congratulate this book for tackling this challenging issue, to which I don't think we have a very good answer by now. And so let's see then. So the chapters in the book I'm really so far most drawn onto are two chapters by Fu Hualin and by Jimmy Jiaxin Xu, one in Taiwan, the other in Hong Kong. So if we see how courts have been reacting to the disobedience movement and those cases trial all the way up to Supreme Court in Taiwan, we see, from my point of view as a constitutional law professor, scholar, lawyer in Taiwan, we see a radical dramatic change. It was never before that our judiciary would ever read the right to disobedience in such profound democratic sense into the essence of criminal law. When I was a student, and even now, it would be a very difficult, almost unthinkable for our courts that have been really into formalistic, very rigid sense of legal interpretation within criminal law to read into the broader and almost unsettling concept of democratic disobedience into those cases. So allow me to say, well, this is how democratic movement, how democracy has changed the law, the most rigidly interpreted, understood criminal justice system in Taiwan. For me, it's a miracle. And I still don't quite get how that was possible. We see the cases, we see how the lawyers argue, we see all these things. But on the other side, we also see our lawyers, judges continue to read conservatively and in a very formalistic sense of the ordinary law, right? So how exactly this democratic unsettling understandings of rights, right to civil disobedience, get into interpretation of our court by judges. So that's one thing. And you can read a very sophisticated analysis by Jimmy Xu in his chapter. But on the other hand, let's look into Hong Kong, right? After national security law. So I will have to be honest, I was really hopeful for the rule of law foundation in Hong Kong, for those very independent judges to be possibly resist on those that has been happened, unfortunately, right? The jailing of all these activists and so on and so forth. But then let's look into Fu Hualing's chapter in this wonderful book, right? So I don't know exactly timing when Hualing finished the chapter. I don't know it was after all these recent national security law and related cases or before. But if we read Hualing's chapter very carefully, he was, if I understand him correctly, still hopeful to see that the kind of rule of law tradition and the impartial judges in Hong Kong would be still possibly guard some of the fundamental basics of freedom of assembly, of the right of these parades, assemblies, according to the existing Hong Kong law, right? There's still a way that the judges can read all these into the law. It's just a particular way for Hong Kong judges to preserve the kind of space for freedom of assembly, to the extent freedom of speech, to continue in Hong Kong, like what was before 1997 and what was after 1997, and even in the beginning of this century, right? But Hong Kong judges were still impartial, hopefully are still impartial right now. But what happened, right? Why a very solid rule of law foundation cannot be read or cannot permit even tiny space for democratic operation or for democratic resistance? What is going on here, right? And and that is what I really want to pose a challenge here, and also perhaps we'll hope some of our scholarship we really get to tackle this really difficult things, right? So let me try some very bold articulations, right? So why Hong Kong's existing judiciary, if with the premise they are still impartial, they are still well trained, they are still operating with the pre-existing case laws, right? And these are still the case laws that we are familiar with, right? And possible of referring to British law, English law, international human rights law, and so on and so forth, right? And then what have been lost in the recent events and the cases where the judges cannot reach to the liberal, I will have to use this word, liberal conclusion as before, right? It is really because of the constraining of law, or it's really because of fear to the Communist Party, the power in China. So we need to know where it goes wrong, right? Is it really the law or it's the power? And in Taiwan, we see the judges are now able to read, for good or for bad, unsettling, broad, democratic concept into criminal justice system, right? So the reason I say for good and for bad is because, well, there's reason for criminal justice and for judges to read narrowly in criminal justice system, right? And then when judges started to have a broad power to instill unsettling concept into the law, it's really for good and for bad, right? This power may be used for good, for broadening the democracy, for encouraging this democratic resistance movement, but maybe for bad. Let's not forget 17th century, 18th century England, right? Those powers can be used by law to punish political dissidents, right? Also through criminal justice, right? So, but then let me shift to Hong Kong, right? So right now, so I want to ask, and I want to encourage a further scholarship is to ask the real question: what impede Hong Kong's and what generate this series of disappointing cases is really from the law or from the fear of power? That's honestly something that I am not sure, right? So I want to say there's still possibilities for law to have transformative power into rule of law and to save democracy. If in the past, Taiwan can do that, why not today's Hong Kong? So in the past, Taiwan's scholars, dissidents, you know, they can, in order to fight democracy, lose their lives, lose their university jobs, you know, lose a lot of things. So on this, I want to echo what Maartje has just said, right? So we constitutional scholars at this historical and important juncture, right? We need to fight not only through our scholarship, but we also need to fight through speaking out of our conscience, through our courage, and also through to support our Hong Kong counterparts, right? Be scholars, law students, judges, dissidents, right? So that's really what I want to make for today. And then let me conclude by draw on this China and the world, right? So this book is titled nicely that Rule of Law of Hong Kong and Taiwan in the Shadow of China, right? So in the shadow of China, but then what are the powers to unpack that, right? And where is the role of the world, the global, right? And then this will remind me myself of my earlier scholarship, my contribution to Brian's first book on Hong Kong and Taiwan. There, my chapter was drawn on how international human rights law was framed and was advocated and was heavily relied upon to shed a new light on how these norms, freedom of assembly, freedom of speech, should be understood and should be given the new opportunity in Taiwan. So that perspective enables both, I think, enables rule of law side, right? Giving the new layer of law, new layer of understandings of rights to Taiwan, and also giving the new possible power to those on politics. And then I think if we want to be out of China's shadow, so what's Hong Kong needing now, and what's Taiwan would move forward will be something that we can unveil China's shadow. And what will be that? How would the regional system in Asia, how would international law, international human rights law can be drawn on to help Hong Kong, right? Or to continue the development in Taiwan. So that will be my take for today. And thank you very much for having me in this event. Thank you.
Wen-Chen, thank you so much. Once again, wonderful comments. I'm sure the Brian and Amy and Chien-Chih will engage with these things, and as we will, as others will as well as we go on. Thanks so much for those very, very rich comments, Maartje and Wen-Chen. Brian, do you have 2 minutes of response, if you wish?
Oh, wow. I don't know if I can do justice in 2 minutes, but I'll try. Thanks so much for the presenters and for the discussants as well. I think you brought up a lot of fascinating topics. I think Wen-Chen, the questions that you posed, I think, are really significant for scholarship going forward. Can rule of law, breed or save democracy? Or can democracy save democracy? Or can democracy also help breed rule of law? And kind of, interacting with those and looking at those in kind of further depth, I think can really help us. And I think you raised some interesting points and some, absolutely critical points about scholarship and kind of where we are right now. And just as Maartje does as well. And I think we're at kind of this significant moment. And I hope that, as scholars, we embrace that moment. So thank you for those. Maartje, fascinating overview of Singapore. And like I said, when we spoke, I wish that Singapore was featured more in the text, but I'm glad that we got that perspective now. And I think it's, a valuable perspective when thinking about kind of China's shadow and how it plays out. And also in terms of kind of an Asian version of militant democracy as well. I think that's an interesting concept. I'm not so sure that I would celebrate the idea of militant democracy. In fact, I've written critically against celebrating militant democracy, but it's interesting, it's playing out in kind of Singapore and in a different context. And just wanted to say, Amy and Zhe, thanks so much as well. Amy, I think you're right, really interesting implications about kind of the scope of the national security law and kind of how that's going to play out beyond kind of what we already know. And Zhe, fascinating in terms of kind of the Taiwanese constitution and the amendment process. And I always wanted to ask, and this is a question for another day, but would it be possible if Taiwan, if replacing the constitution would be considered, such a potential threat? What about scrapping the constitution completely? I just wonder, and not replacing it. I just wonder kind of how that would play out. But that's a question for another time. But thank you so much, Asanga, for the invitation. I'm really, happy with how the event unfolded. Thanks a lot.
Thanks very much, Brian. Thanks everyone again. Really very rich comments. We have